Greetings and welcome to Jurisdiction, Transitory, and Local Actions from American Jurisprudence. And greetings to Bill Thomas. So, we're going to be going over jurisdiction as it applies in transitory actions and in local actions. And of course, we'll have Black's Law Dictionary at our ready to help us with any words that we're unfamiliar with to make sure we leave no word behind. With that said, let's get started. So this is from American Jurisprudence, second edition, and the May 2022 update. This is from Courts, Volume 7, Jurisdiction, and Classifications of Jurisdiction. We're going through the jurisdiction as to transitory actions and local actions. And starting with Section 77 within this volume, which is generally. Jurisdiction in personam and jurisdiction in rem are related to jurisdiction of transitory actions and jurisdiction of local actions, since a court has jurisdiction over a transitory action when it has jurisdiction in personam over the defendant. Transitory actions are personal in nature, and jurisdiction is usually proper in any county where a material defendant can be found. The nature of a cause of action as transitory or local depends on whether it seeks a decision operating in personam or a decision operating in rem. In order to determine if an action is transitory or local, the court must look to statutory and common law. A particular cause of action created by a statute can be made local if the statutory provisions limit actions for enforcement to a particular court. We're going to get into these details and the observation in just a moment, but I believe that before we go further, we need to clarify this term of transitory actions. And best to do that by going over here to Black's Law. So let's do that. And let's see here. Let's move into the A's. Action should be on this page here. Here we go. Action. So action from the 14th century. The process of doing something. Conduct or behavior. 2. A thing done. An act. So an action could be the process of doing something. Conduct or behavior. An act, right? A thing done. It could also be an act. In patents, it's office action. There's advisory action with patents too, but we're not getting into that. Then we get on to definition number 4. A civil or criminal judicial proceeding. I think this is the one we're looking for. Also termed action at law. Before we get into detail, I think it's worth reading this little paragraph here. An action has been defined to be an ordinary proceeding in a court of justice by which one party prosecutes another party for the enforcement or protection of a right, the redress or prevention of a wrong, or the punishment of a public offense. But in some sense, this definition is equally applicable to special proceedings. So special proceedings too. More accurately, it is defined to be any judicial proceeding which, if conducted to a determination, will result in a judgment or decree. The action is said to terminate at judgment. So there it is. It's more accurately defined to be any judicial proceeding which, if conducted to a determination, will result in a judgment or decree. So that's what an action ends up being. The terms action and suit are nearly, if not quite, synonymous. But lawyers usually speak of proceedings in courts of law as actions and those in courts of equity as suits. And we learned earlier too. Sometimes the judgments are looked at as judgments in laws. In I'm sorry, in civil cases and decrees, and as a result of the equity suits. In olden time, there was a more marked distinction, for an action was considered as terminating when judgment was rendered, the execution forming no part of it. A suit, on the other hand, included the execution. The word suit, as used in the Judiciary Act of 1784, so this is important right here. The Judiciary Act of 1784 and later federal statutes, which are statutes at large here, applies to any proceeding in a court of justice in which the plaintiff pursues, in such court, the remedy which the law affords him. So this is something worth digesting here. And before we do that, let me pop over to the chat really quick because we're getting pretty in depth here. Welcome to Metal. Yeah, we're going to learn something really good. This won't be hard. We're just, I just like to throw you in the deep end to see where we're going. So generally what they're getting at here is that an action, so an action can be an inaction, is a conduct in action. Yes, a conduct is an action. It's not necessarily an inaction. An action must be an action, I guess, by definition. That being said, as we see here, when we're talking about an action in a judicial proceeding, that an action is something which, followed to its termination or determination, will result in a judgment or decree. So now we're getting down to the action in the sense, hang on a second, there we go. Action. Oh, shoot. Hang on a second. There we go. Action in the sense of a judicial proceeding includes recoupment, counterclaim, set-off, suit in equity, and any other proceedings in which rights are determined. And that comes from the Uniform Commercial Code, section 1-201. Looks like an I in parentheses there, not too sure. Or a 1, or an L. That being said, action at law, a civil suit stating a legal cause of action and seeking only a legal remedy. So before we get any further, we were looking for transitory action. So let's scroll down until we cruise through all these actions. This is, take note, these are all part of definition 4 of action. And we need to reread some of these here to on our way, like action in personam. Personam. Okay, personam. 1800. An action brought against a person rather than a property. An in personam judgment is binding on the judgment debtor and can be enforced against all the property of the judgment debtor. An action in which the named defendant is a natural or legal person. Also termed personal action in Roman and civil law. All right, so we also had action in equity, seeks equitable relief such as an injunction or specific performance as opposed to damages. So again, we were going for, we had an action in rem that they mentioned as well. Did we pass that one? Here we go. Action in rem, an action determining the title to a property and the rights of the parties, not merely among themselves, but also against all persons at any time claiming an interest in that property. A real action. So now we're on to real action here. In Louisiana law, it's an action brought for the protection of possession, ownership, or other legal rights in immovable property. A lot of Louisiana here. All right, so action in rem is an action determining the title to property and the rights of the parties, not merely among themselves, but also against all persons at any time claiming an interest in that property. So it's a real action. Action in rem is a real action. Okay, so let's see. So it's actiones in rem, an action in which the named defendant is real or personal property. So the defendant, this seems kind of strange that a defendant would be the property, but that's what that means. So now that we know that, let's get to the definition we were really out for, which was transitory action, and here it is. Transitory action, an action that can be brought in any venue where the defendant can be personally served with process. Let's break this down now. That's pretty broad. Transitory actions are universally founded on the supposed violation of rights which, in contemplation of law, have no locality. They are personal actions, that is, they are brought for the enforcement of purely personal rights or obligations. If the transaction on which the action is founded could have taken place anywhere, the action is generally regarded as transitory. But if the transaction could only have happened in a particular place, the action is local. Some authorities, considering the effect of the distinction, define transitory actions as actions which may be tried wherever the defendant may be found and served. And this goes into Corpus Juris Secundum about venue in Section 8. So we could look that one up too, but not tonight. That being said, we see here as the transitory actions as opposed to local actions here. And depending on the authority too, where it's being determined, also makes a difference here. So again, we're going to get into this further. Down here, this action with there's another definition of former independent federal agency. This is not what we're looking for, but this is the end of the definitions. Looks like the last one of the whole number 4 definitions of action. So that being said, we can figure out that it could only have happened in a particular place if it's transitory. It's local. If it could only have happened, but if it could be found it could have taken place anywhere, then it's generally regarded as transitory. So it's supposed violation of rights, right? These are actions that are universally founded on the supposed violation of rights, which, in contemplation of law, have no locality. They are personal actions. They're brought for the enforcement of purely personal rights. So again, we have some purely personal rights. We have other operating words here like universally founded. Then we have supposed violation, contemplation. So look at a lot of these words here that are qualifiers of what comes after. If the transaction on which the action is founded could have taken place anywhere, the action is generally regarded as transitory. Now that we have a good overview of transitory versus local actions, let's get back to American jurisprudence. But before we do that, let's quickly check on the chat here. Indeed, Bill Thomas, the details that make the definition solid are important. And yes, you'll have a more credibility showing a deep understanding, but better than that is that as we go through this material, it will all make a lot more sense. And yeah, real action as in real property or real estate indeed. All right, let us proceed. So let's start here again, section 77 generally. In order to determine if an action is transitory or local, now that we have this distinction in our minds, the court must look into statutory and common law. A particular cause of action created by a statute can be made local if the statutory provisions limit actions for enforcement to a particular court. We have a lot of footnotes, so let's start with our observation here. For jurisdictional purposes, there is a fundamental difference between criminal causes of action and personal injury causes of action. Namely, personal injury claims are transitory in nature, while crimes are inherently local. Another great distinction here. A state cannot create a transitory cause of action and at the same time destroy the right to sue on that transitory cause of action in any court having jurisdiction. Rather, jurisdiction is determined by the law of the court's creation and cannot be defeated by the extraterritorial operation of a state statute, even though it created the right of action. This looks pretty interesting too. We're on to the cumulative supplement here. The general rule insofar as subject matter jurisdiction is concerned. We're on a subject matter jurisdiction here now. This is the first time we've come into this on this presentation here. Is that when the suit is based upon a contract, the action is transitory and may be determined by any court which can obtain jurisdiction on the person without regard to its place of execution or performance. Interesting. That's from Wyoming in 2019. So that's a very recent case there. So let's look over these, a lot of good footnotes. The first one was jurisdiction in personam and jurisdiction in rem are related to the jurisdiction of transitory actions and jurisdiction of local actions. So that comes from footnote 1. Okay, so that was earlier. And we have footnote 2, when it has jurisdiction in personam over the defendant. White versus PepsiCo, Florida, 1990. Let's see here. There's no other footnotes for these here, but we can see they're rather recent cases that are being cited here, and this is a 2022 supplement. So I would say that these are pretty well established here as far as any of the applications here of local rules. Number 7 is an interesting one too. That's Marshall versus Marshall. Okay, and that was 2006. Right, now we're getting on to Section 78, actions concerning real property generally. And again, this is, as we were saying in the definition there too. Let me jump over to the chat here real quick, make sure we're all caught up. Indeed. Refresh it just to make sure. All right, so now we're on to this, as was requested. Let's do it. Actions concerning real property generally. Although an action involving real property is not necessarily local in character when the decision sought is not of a nature to affect the title to real property, an action which seeks a decision operating directly on real property is local and not transitory in nature. So it's not necessarily local if it's involving the property, but when the decision sought is not of a nature to affect the title. So there it is. That's your distinguishing character there. Then an action which seeks a decision operating directly on the property is local. So title, if it's involving title, it could be transitory. A court's jurisdiction to adjudicate personal interests in real property is a transitory action, while a court's jurisdiction to adjudicate legal title to real property is a local action that must be brought in the situs state. Wait, do we get this backwards here? Although an action involving real property is not necessarily local in character when the decision sought is not of a nature to affect the title. There we go. When the decision sought is not of a nature to affect the title to real property. So this a little tricky sometimes. You got to read every word carefully. When the decision sought is not of a nature to affect the title to real property, then it could be transitory. But an action which seeks a decision operating directly on the real property is local and not transitory. So if it's on the title, what was the one? Not necessarily local. But if it is directly on the real property, it is local. Court's jurisdiction to adjudicate personal interests in real property is a transitory action, while a court's jurisdiction to adjudicate title, legal title to real property is a local action that must be brought in the situs state. Indeed, in actions involving land outside of the state, if the crux of the action does not hinge on the resolution of specific to the land, of issues specific to the land, but upon the conduct of the person, then the cause should be deemed transitory. So, issues specific to the land, but upon the conduct, that could be deemed transitory, may be maintained in the state. Indeed, in certain jurisdictions, an action for damage to real property need not be brought in the state in which such property is located, where an action does not concern the title to the property. Ooh, okay. So I wonder how this would be affecting liens for those kind of actions if it's brought into another state. So yeah, there's some interesting points here. This is a pretty deep one here. Of course, the first statements here, when they use words like sought is not of a nature, not necessarily, meaning that it's not necessarily when it's not affecting the title. It may be, but it may also not be. But if it is regarding directly on the real property, it's local and not transitory. So there's no option there, is what they're getting at. And then these cases will be the ones that are being referenced. So number one is where you have a choice, and that was Roberts versus Cooter, 1959. And number two is where it must be local, and that is Miles versus Chinto in 1944 here to 1945. So well-established law you got right here, or it's been operating for quite some time. Excellent. Let's proceed from here. Now we're on to section 79, tort actions. And real quick here, let's jump over to the chat. Bill Thomas says, a challenge to a local restriction on drilling water wells would be local or transitory if the restriction was county-wide. Of course, disclaimer here really quick, this broadcast is strictly for the educational entertainment purposes of this YouTube broadcast and live stream, and not to be used, construed for anything professional, personal, private, business, tax-wise, financial or otherwise, or legal lawful. Don't do this at home. All right, that being said, I wouldn't consider it anything other than local because it's affecting a title which would be mineral rights or below the ground rights, and that might be title issues involved in that, so perhaps that should be local, it seems to me. But again, that's just my opinion. All right, let's proceed. So an action in tort for personal injuries is transitory, and a claim that is transitory in nature may be tried wherever jurisdiction may be properly established over the parties, regardless of the place where the cause of action arose. So tort actions are transitory. Straightforward, simple. Back with our PepsiCo case in 1990 in Florida, and Mendoza versus Neudorfer Engineers in 2008. And moving on to Section 80, contract actions. When the cause of action is based on a contract and the action seeks damages on the ground of breach of contract, the action is transitory in nature and may be adjudicated by any court which has jurisdiction in personam of the defendant, irrespective of where the contract was concluded and irrespective of where it is to be performed. An action questioning the validity of the assignment of a contract or seeking cancellation of a contract is transitory in nature. So, the transitory nature of a cause of action based on a contract is not affected when real property is incidentally involved. Thus, an action for payment of a promissory note is transitory even when the note is secured by a mortgage. Whoa, let's see here, number 5. 1945, Hope Hodgevall versus Hodgevall in Montana. Now, that would be an interesting case to research. The transitory nature of a cause of action based on a contract is not affected when real property is incidentally involved. Thus, an action for payment of a promissory note is transitory, even when the note is secured by a mortgage. So that means that a lot of these mortgage foreclosures and promissory note debt collection is a transitory action and can be heard in a number of venues, it seems. Well, that's some interesting insight there. Section 81, ancillary jurisdiction. Let's pop over to the chat here real quick. All right. I appreciate your opinion and accept all disclaimers with a full understanding. It is my obligation to get proper legal advice. Well, I didn't say that either. I just gave you my opinion. I always say work on your own critical thinking. Although the primary jurisdiction of a court is its power to hear and adjudicate the cases before it, it also has ancillary jurisdiction to take actions that are incidental to the exercise of its primary jurisdiction. This is implied in the grant of the primary jurisdiction. In the Marriage of Parks, 1987. Wow. Thus, a court acquiring jurisdiction over property can determine all questions relative to its title, possession, and control. Because ancillary proceedings aim to further a principal proceeding, they can only exist by virtue of the main cause of action, and without the main cause of action, they would not be required. Also, in the exercise of its ancillary powers, the court can exercise reasonable control over all proceedings connected with the litigation before it. However, the doctrines of ancillary, pendant, or supplemental jurisdiction have been held not to apply in state courts, and a state circuit court has thus been held to have no authority to exercise jurisdiction over a statutorily created claim exclusively cognizable in the district court solely because it was filed as a compulsory counterclaim. Well, that's footnote 6. Let's see what that one is. Oh, great. So Jackson versus Davis, Alabama, Appellate 2014. Oh, geez. So that looks like one to untangle there. Those, when there's a sentence like this, or as a paragraph or sentence, whatever that is, that's clearly taken from that case, and it applies in that situation, which was brought to appeal. So it is generally a holding that can be referred to if you have a similar situation. All right. Let's proceed. Enforcement of decisions, Section 82. Jurisdiction is, among other things, the power of a court to enforce judgment. A court that has jurisdiction to make a decision also has the power to enforce it by making such orders and issuing such writs as are necessary to carry its judgment or decree into effect. For example, it can issue a contempt order. I love the example. Number 4, Lake of the Woods Club versus Martineau, 1958, in Indiana. For example, it can issue a contempt order. So jurisdiction is the power of the court to enforce judgment. Court that has jurisdiction to make a decision also has the power to enforce it. So jurisdiction is ultimately the power to enforce judgment. And for a discussion of enforcement of judgments, we could look at executions and enforcements of judgments, sections 655 to 834. And as to contempt orders, if you want to have more about the contempt orders, we could look under contempt under second edition, section 1, and the rest after that. All right, which brings us on. Let's see here. Concurrent jurisdiction, section 83, the nature and scope of the rule. Before we get onto this, let's check on to the chat here. All right, glad you made it back here. Captain Jack, welcome, greetings. And yes, please hit the like, everyone. Let people know that we're here learning about some important stuff and having fun too, I hope. Freezing out. Yeah, well, we'll try and keep it moving along here and slow, and so you can catch back up. Let's see here. Diesel for the We the People news, which means the prosecutor or the claimant must have standing of subject matter jurisdiction or personal jurisdiction. Indeed. Cognizable. Yeah, that's a tough word to say there properly, so I just took my stab at it. All right, let's proceed. We're on to the nature and scope of the rule. The exercise of concurrent jurisdiction. So this is, we're under C here, concurrent and conflicting jurisdiction, and the priority as controlling exercise of concurrent jurisdiction. So this can relate in issues where we have, could it be a transitory action? Could it be a local action? And then there's concurrent jurisdiction. It's controlled in general by the jurisdictional priority rule, which is sometimes referred to as the rule of exclusive concurrent jurisdiction. Wow. Exclusive concurrent. According to this principle, the court, which first exercises this jurisdiction, acquires exclusive jurisdiction to proceed with the case, even though other courts in the same state have concurrent jurisdiction in the matter. I see. In other words, once a court of concurrent jurisdiction has begun to exercise its jurisdiction over a case, its authority continues until the matter is completely disposed of, and no other court of concurrent jurisdiction can interfere with the proceedings. Wow. It continues until the matter is completely disposed of, and no other court can interfere. All right, so once jurisdiction over the parties and subject matter has been secured, it is retained to the exclusion of other courts of equal competence until the case is resolved. And the rule applies where the subject matter before the separate courts is the same, but the actions are in different forms. The jurisdictional priority rule applies to state courts of concurrent jurisdiction. However, the rule does not apply if the first action terminates before the second action commences. Okay, well, that makes sense. If it's terminated, then there's no priority. When several courts have concurrent jurisdiction, the plaintiff can select the court in which to bring the action. So the plaintiff gets to select the court, and this choice is binding on the defendant. When several courts. So in some states, the service of process determines priority, while in others, the filing of the complaint, bill, petition, or other equivalent pleading determines exclusive jurisdiction. That's footnote 10. So let's see, footnote 9, process determines priority, and footnote 10, where you put the petition is the filing of that determines exclusive jurisdiction. 9 is Florida 1981, and that's service. And then 10 is in marriage of Huss in Indiana 2008. All right, so let's see here. The cumulative supplement here, the case is a priority jurisdiction which abates an action where a prior action is pending in a court of concurrent jurisdiction between the same parties over the same controversy, cannot apply after a final judgment has been entered. However, a summary judgment ruling is not final for purposes of priority jurisdiction while a motion for new trial or amendment of judgment is pending. Now, that's a good one there. And that's 2015 in Mississippi. This is a great one here. So the priority jurisdiction, which abates an action where a prior action is pending in a court of concurrent jurisdiction between the same parties over the same controversy, cannot apply after final judgment has been entered. However, a summary judgment ruling is not final for the purposes of priority jurisdiction. Excellent. So let's continue on here. As the priority principle as between courts of different states, see sections 84 and 85. And here we are, section 84, nature and scope of the rule, requirement of identity of actions. In general, the jurisdictional priority rule applies when the causes of action are the same in both cases. And if the first case does not involve the same cause of action or the same parties as the second case, the first case will not prevent the second. In other words, the rule that priority controls the exercise of concurrent jurisdiction applies only when the cases involved are identical as to subject matter, parties, and relief sought. That's footnote 2. That's Bunch versus Nationwide Mutual Insurance, 2014. A more liberal variation of this rule stated by some courts is, where there is a substantial identity of the parties in two actions, the actions are sufficiently similar, and the relief sought is substantially the same, a court has broad discretion in determining whether an action should be dismissed on the grounds that there is another action pending. The critical element is that both suits arise out of the same subject matter or series of alleged wrongs. The rule of exclusive concurrent jurisdiction thus may not require that the parties in the two actions are entirely identical or that the remedies sought by the two actions are not precisely the same. Instead, it is sufficient for the exercise of equitable jurisdiction that the issue in both actions is the same and arises out of the same transaction or events. So again, it's not down to the extreme details and dollar amounts or quantities, but the qualities of the transaction or events between the parties. The elements of the rule are not to be applied inflexibly. Moreover, the identity must be such that a final adjudication of the case by the court in which it first became pending would, as res judicata, must be a bar to a further proceeding in a court of concurrent jurisdiction. And that's footnote 6, which is, see, Ohio, 1997. And let's look at our cumulative supplement here. Our cases are prior pending equitable distribution action did not divest trial court of jurisdiction to consider wife's and plaintiff businesses breach of fiduciary duty, breach of contract, and quantum mercuit claims against husband and defendant businesses where wife and plaintiff businesses claim damages in excess of $25,000. Plaintiffs could collect from husband's separate property if they prevailed on breach of fiduciary. Well, this looks like a really complicated case here. Breach of fiduciary duty. I'm not going to read into this because that takes a lot of attention. That's specific to that case. Let's look at that's cited right there, 2016, North Carolina. The doctrine of prior suit pending requires proof of the following 4 elements. So here we go. Number 1, the lawsuits must involve identical subject matter. 2, those lawsuits must be between the same parties or their privies. Or 3, the former lawsuit must be pending in a court having subject matter jurisdiction over the dispute. So they need to have proper standing in that matter. The former lawsuit must be pending in a court having personal jurisdiction over the parties. So both of those forms of jurisdiction. Deferral to another state court where the action is pending in that state court applies where parties, subject matter, and remedies are precisely the same. And it also applies where they are only substantially the same. And it also applies. So there it is. Not looking for the details in that respect. And now we get to the nature and scope of the rule, Section 85, qualifications and exceptions, comity. We went over this briefly in distinctions for this and the, here we go, the full faith and credit principles and comity. So the difference here, and I guess we'll go over it in more detail right now before I digress. The rule of priority does not apply as a matter of duty between courts of different states. However, under the doctrine of comity, one court should defer action on causes properly within its jurisdiction until the courts of another sovereignty with concurrent powers and already cognizant of the litigation have had an opportunity to pass upon the matter. Thus, under the doctrine of comity, a state court usually would stay its proceeding pending the adjudication of the first filed suit pending in another state. In order to obtain a stay of a later filed action in favor of a prior filed action in another state, it is necessary that the two suits involve the same subject matter, involve the same issues, and seek the same relief, as we learned before. Also, in view of the full faith and credit clause of the federal Constitution, once the proceeding on the case has been finally adjudicated by the court of a sister state, res judicata effect must be given to it by the court of the forum state. So, what we're looking at here is that it's a sister state. Anything that's being adjudicated between a sister state is where the full faith and credit clause would apply. And as a matter of duty, let's see here, the rule of priority does not apply, but under the doctrine of comity, one court should defer action on causes properly within its jurisdiction until courts of another sovereignty with concurrent powers and already cognizant of the litigation have had an opportunity to pass on the matter. So there was a state court would stay its proceeding pending adjudication of the first filed suit pending in another state. So, doctrine of dominant jurisdiction, under which a later filed action should be abated in favor of a prior filed action pending in another court, does not apply to suits pending in other states. That would be with a full faith and credit clause, right? We didn't get to the end of this here, do we? The rule of priority also does not come into operation when there is no identity of action, parties, issues, and relief. Those are our main criteria there. All right. So these are reiterations. We get comity vests in the sound discretion of the trial court as international. That's under federal courts. And then we have, let's see here, 1926 American Law Review. Interesting. That was, let's see, what footnote was that? That was pretty old. Number 6. And that's this one here. Once a proceeding on the case has been finally adjudicated by the court of a sister state, res judicata effect must be given to it by the court of the forum state. Okay. And we're on to application of rule to real property. Before we do that, let's jump over to the chat here. Let's see. Contempt of court, huh? Would that be civil contempt or would it be criminal contempt, Your Honor? Well, remember, we're reading from American jurisprudence here, and sometimes, especially some of these newer editions, they're written for the law society there, so to speak, legal society. Exclusive concurrent still sounds like an oxymoron, but I get it. Yeah, it's a nice one there. It's, I guess, the best way they could try to massage it in there for the cases they are citing. Foreign courts can also cause the doctrine of comity happen. Yes, indeed. All right. So let's proceed here under the application of rule to real property. When property is the subject of controversy, the court of concurrent jurisdiction, which first exercises judicial control over the property, has exclusive jurisdiction. However, the jurisdiction acquired by the court first taking possession is exclusive only insofar as the exercise of this jurisdiction is necessary for the appropriate control and disposition of the property. Okay, so there it is. The other court does not thereby lose its powers to make orders which do not conflict with the authority of the court which has control thereof. Moreover, a trial court in a mortgage foreclosure action is not precluded under the jurisdiction priority rule from appointing a receiver over the subject property, even though a different court in a landlord-tenant action involving the same property had previously appointed and subsequently terminated a receiver over the property, since the two actions were separate and distinct. Oh boy. Landlord-tenant action. Wow, that one looks, number 3. Yeah, 2009 sounds about right. Cuyahoga County. Okay, so let's proceed from there. All right, I think that takes us to the end of this section here. All right, I want to thank everyone for showing up here tonight. Let's quickly go over to chat. Excuse me one second here. There we go. All right. Yeah, don't rely on any thoughts for any of this stuff, but I'm glad you all enjoyed this. At least Bill Thomas did from the chat here. I definitely want to ask, please hit the like if you could, so that we definitely get the word out. More people can show up here and give their feedback, because I think this is the best way of really finding some of these little hidden gems that we can find when we dig deep in the meaning of some of these. Actually, they're functions of the courts that touch upon everybody's lives, especially when we talk about things like jurisdiction, real property, and the like. We touched on all of these things: tort actions, civil actions, equity. Jurisdiction touches all of these, and transitory action or local action is one of the foundational ones of figuring out what the proper venue for the cause of action will be. So we pretty much rounded all that up. I want to salute you all for coming out here, and I know there's a lot of other drama and fun stuff to watch on the YouTubes, but getting some value out of a video is something that's really a remarkable thing to take advantage of these days. So salute you all for being here, and I hope to see you all on the next one. Peace out.